everyone. How are you? Hello. Welcome to another session. This is Lawyers Infohub. This is a platform where we reach out to law students, lawyers, anyone interested in law. We share knowledge, we share legal principles, we share legal experiences, we bring lawyers to come talk to us to enable us, gain from their experiences and also, learn one or two things. We just want to support the legal education in Nigeria, in Africa, and beyond. We believe that knowledge is power, and when you stop learning, you start dying, you start going down. The more you learn, the more you grow. So today we're looking at the concept of arbitrability. Yes, the concept of arbitrability. This is a concept you see in arbitration. And you agree with me that with the advent of technology, with the things are becoming a lot easier, and a lot of people are moving away from litigation, and they are trying to look for other ways to resolve their dispute without really wasting so much time, without spending so much money at the end of the day, so that both parties can resolve their differences and and move on. So arbitration has come to stay, and a lot of lawyers are asking, "How do I become an arbitrator?" and all that. This will be another video I will do on how to become an arbitrator, a certified arbitrator, and jobs you can do as an arbitrator, things you can also do in line with it, as with your job. So you can also be a certified arbitrator and also a lawyer. It is another stream of income. Yes, and we have few arbitrators. They are not more so much. They are there, but not so much. So we need more people to become arbitrators. Yes. You can also be a certified mediator. You can also be a certified negotiator, depending on your choice. For you to understand what exactly you want. So, looking at the concept of arbitrability, now you ask yourself, what is arbitration? Literally, when people, you know, come together to submit their dispute to, to a person or uh, persons who are acting in judicial capacity or judicial manner rather than the court of competent jurisdiction. What I mean is that whereby two people who are having issues or who have disputes will now submit their dispute to a third party who we call it or persons under the auspices of an arbitral body to mediate or no to arbitrate, not to mediate, to arbitrate on their issues. This body they are not the court, you know, but they stand in the judicial capacity to arbitrate on those matters. Now, you also need to know that as much as arbitration is a form of a dispute resolution, but it has its differences with ADR. Yes, one thing I need you to know that many people also see arbitration as a reference of a dispute or future dispute. Yes, in a contract, you see people are trying to enter into a contract and they're saying there's a possibility that we will end up having issues. Peradventure, there's a breach or one person fails to do something that you're supposed to do. We are going to refer this our dispute to to an arbitrator. Yeah, so reference of a dispute or a future dispute, because when people enter into contracts, they do not even envisage there'll be trouble or they won't envisage there'll be dispute, but they're saying peradventure there's a dispute. They're going to refer this to arbitration. So a reference of a dispute or a future dispute between two or more parties to an independent person or persons, for adjudication. Now, it's very important to note the differences between alternative dispute resolution known as ADR and arbitration. Many people confuse these two together. You know, alternative dispute resolution, no, formal or normally known as ADR, is a generic word, which refers to alternative options to resolving disputes, ranging from, we have the mediation, conciliation, we have the early neutral evaluation. So these are the forms of alternative dispute resolution. Now, Although arbitration is an alternative to litigation, but it is not really classified with these other forms of alternative dispute resolution. Because these other forms of alternative dispute resolution is limited in terms of non-binding procedures. It is non-binding in that it is not being imposed. The decision is not being imposed, but voluntarily entered between the parties. You know, Unlike an arbitration, which is at the end of the day their word, is binding and can be enforced, by you know the party in whose favor it is given. As much as ADR, offers or complements effective or has, well, I say effective, complement to litigation process. Yes, a lot of people will say let's try ADR because litigation is expensive and all of that. Yeah, so many people also say no. As much as I want to do ADR, I prefer to do arbitration. So, what stands arbitration at aside with these other forms of ADR is that binding nature, the binding nature. Thankfully, in our courts and different jurisdictions, there are proliferation of a multi-door courthouse, mediation centers here and there. Many states are now embracing it, so that in your local government, in your jurisdiction, anywhere you are, you can find a mediation house, to reduce the workload in court, and to let people know that litigation is not always the way. We can find a way around it. Now, given this background, let's now move into the concept of arbitrability. Yes, the concept of arbitrability. See, in arbitration, there are fundamental principles. And arbitrability is one of those core fundamental principles. We have the party autonomy principle, we have the separability of the agreement contract principle, we have the competence principle, and we have the arbitrability. So today we're looking at the concept of arbitrability. From the word arbitrability, it's just referring to the capacity of a matter to be legally settled by arbitration. Yes, it's as simple as that. The capacity of a matter to be legally settled by arbitration. There are matters that cannot be settled by arbitration. So arbitrability is saying this dispute that be referred to an arbitrator or to be referred to arbitration, is it capable of being settled through arbitration? So, it's also very important when you talk about arbitrability, you sort of look at public policy limitations. It is relating to public policy limitations. So people look at it, is this matter, is this something of public policy? Can it be settled through arbitration? Is it something that is only to the exclusive preserve of the courts, the national courts? So these are things you must understand and note as a lawyer, as a law student who is in the position of advising clients, who is in the position like a doctor dissecting issues, and someone you're drafting a contract with for a client, and the issue of arbitration comes in. You know that the clause for the arbitration is very vital in every contract, and you're drafting that contract, and the issues or the subject matter are not capable of being arbitrated upon, and you still put in that arbitration clause. But if a lawyer who is knowledgeable understand that the particular subject matter is not something that can be arbitrated upon, so these are things you need to know as a lawyer to make you different from others, so that you see that sometimes when those matters now are being submitted to arbitration, objections can be raised and say these matters are not matters that can be, arbitrated upon. um, you see that we have a lot of cases, the Nigerian cases too, on this concept of arbitrability. In the course of time, I'll state one or two of these cases for your own further reading. Now, you must also understand that the question of arbitrability is different from the question of jurisdiction. Many times people confuse arbitrability with jurisdiction. Arbitrability is the ability of that's the capacity of a matter referred to arbitration to be successfully settled by arbitration. While issues of jurisdiction are talking about the power of the arbitral body or the arbitral tribunal to even hear or to arbitrate. So arbitrability is different from jurisdiction. Now, it's very important to ascertain, determine arbitrability, because when people flood or people are saying, well, let's submit to arbitration and all that, they ask yourself basic question: Are these issues capable of being arbitrated upon? So when a dispute is not arbitrable, then you can't talk about arbitration. Now, um, there are there are certain issues, subject matter that are preserved of a court. Now, for example, in our jurisdiction, the Federal High Court, by the provisions of Section 254 of the Constitution, there are certain issues that cannot be, you know, instituted in another court than the Federal High Court. So in such instance, you see that once is these issues, it is only the Federal High Court that has jurisdiction. So when you now take that matter and now want to that matter under Section 251, I want to take it to arbitration. You know that arbitration will still arise that these matters are not arbitrable and cannot even fly. So that it is the preserve of the Federal High Court, for example, to handle the matter. Now, arbitrability is closely linked to public policy. Various countries, prohibit settlement of certain disputes by arbitration on grounds of public policy. You know, um, you see that the New York Convention, the Ancestral Model Law, these are conventions under arbitration, also make specific reference to issues of arbitrability and the issues of public policy. Now, the New York Convention, um, you know, state that that where disputes are incapable of settlement by arbitration, then they are non-arbitrable. So you see that there are subject matter that are arbitrable and there are those that are non-arbitrable. So these international conventions, like the New York Convention, the Ancestral Model Law, and all, they all make reference to arbitrability because it's one of the pivotal fundamental principles of arbitration. So if a matter is not arbitrable, then it cannot be submitted to arbitration. You know, as much as arbitration is a matter of jurisdiction, but you see that jurisdiction is not always an issue of arbitrability. Yes, because if a matter is not arbitrable, then arbitral tribunal cannot even assume jurisdiction because what you are bringing before them, normally should not even have been brought. So arbitrability is a matter of jurisdiction, but jurisdiction is always not always an issue of arbitrability. So I really said that arbitrability relates to the capacity of a dispute to be settled by arbitration, and non-arbitrable matters are not within the jurisdiction of an arbitral tribunal or an arbitral body or any form of arbitral body. So so we're going to list out non-arbitrable matters so that the course of your work and the course of your practice, if you are fortunate enough or your opportunity to have issues like this, you know that these ones are not arbitrable. So we're going to look at non-arbitrable matters. Now, banks, actions against banks. Actions against banks that is being subsumed under the BOFIA, that is the Banks and Other Allied Matters Act. These are not arbitrable matters. They're not arbitrable banks. So it's the BOFIA Act that regulates banks and other financial institutions. So that BOFIA Act stipulates how to go about matters of banking matters and all of that. Now, issues of bankruptcy, issues of insolvency, they are non-arbitrable. Issues of bankruptcy insolvency regulated by the Bankruptcy Act, the CAMA. So they make provision on how to declare a person bankrupt or on and how to go about recovering, debts and all of that. So it is not a matter of arbitration. Just like the CAMA also makes provisions for issues of a winding up of insolvent companies, how the winding up can be done, and what are those things you need to see in a company to say this one is to be is cap or is to be winded up. So it is the karma that makes provision for all these things. So we have the bankruptcy act, like I earlier stated. So issues of crime are not what arbitrable. the criminal code, the administration of the criminal justice, all of them make provision on how to go about it. So on issues of crime, they are non-arbitrable. The on Matrimonial Causes Act, the Matrimonial Causes Act makes provisions for matrimonial causes. So jurisdiction in matrimonial cases are causes are vested in the High Court. So they are not arbitrable, even though issues of terms of separation can be arbitrated upon. Terms of separation can be arbitrated upon. Issues of revenue taxation, they are not they are non-arbitrable. The Constitution has invested them on the Federal High Court as the exclusive court to handle issues of revenue taxation. I know, so um, they are in the exclusive preserve of the Federal High Court, so they are non-arbitrable. Okay, issues of copyright, patent, and all of that too. You know, even though some countries are making some adjustments to their laws to accommodate some of these things to become arbitrable in the light of the way the world is turning and the development, technology, and all of that. But in our jurisdiction, these are not arbitrable. Yeah. So arbitrability is crucial in actions also brought to enforce an award. When there is arbitral award on a matter that is not arbitrable, then you know that the award cannot be enforced. So we have to understand this is very, very important. At the model law, that's ancestral law, the New York Convention, even our own Arbitration and Conciliation Act, have all made provisions for issues of arbitrability. So arbitrability is uh, is pivotal, very, very pivotal. It has to be, looked decided upon before even a matter who can proceed to arbitration. And the matter subject to arbitration is it uh, disputes that can be resolved through arbitration. So if you can answer this question, it helps you to even sort out the issue of jurisdiction. Because just like I told you that arbitrability is an issue of jurisdiction, even though jurisdiction is not always an issue of arbitrability. So we must understand the differences between arbitrability, jurisdiction, what are the matters that are non-arbitrable, which courts can handle this. This gives you an idea so that when you're giving an opinion or when you're talking to someone about issues of arbitration, be able to do, okay, this matter, we can, if there are issues when you're drafting a contract, you'll be able to know which of these disputes can it be arbitrated upon? Do I need to put the clause there? Is it something, or your someone comes to you and says, okay, these people have gone to arbitration. You know that these are not matters of arbitration. You put up a period objection on the jurisdiction of even the arbitral body to entertain the matter because of its own arbitrability. So when matters are not capable of being arbitrated upon, so it is a waste of time for an arbitral body to proceed to arbitrate on them because the award cannot be enforced. So I just hope you've learned something on the concept of arbitrability. I told you that is a fundamental principle in arbitration, amongst others like the competence, separability, party autonomy, and the rest. So we'll be able to discuss those issues that are non-arbitrable. We've also been able to discuss that issues of arbitrability and jurisdiction. Just hope you've learned something in today's class. If you're yet to subscribe to this channel, please do hit the subscribe button. Just to hit it. We appreciate it. And for those who have subscribed and keep watching our videos, we are very grateful. Like, you're one of the reasons why we are here. You keep encouraging us even when we want to give up. You keep pushing it, and you know that knowledge is power. People love knowledge, and if it is easily accessible, it will make more sense. So do have a beautiful day. Do have a beautiful time. Do know that you can always be the best. Wherever you are, the best is also yet to come. Keep rising, keep improving yourself. It can only get better. Yes, it can only get better. We'll keep moving. The sky can be a stepping stone. To take care of yourself.